Okay. There we go.
All righty. All right, we're live streamed. Ladies and gentlemen, thank you for joining us today. Today is March the 15th, and we're going to go through several bills, and the bills we're going to go through are as follows. HB 150, HB 151, HB 331, HB 639, and HB 691. We will start with HB 150. And Matthew, if you would give us a brief overview of HB 150 while I get myself set up here.
Mr. Chair, did you send another?
All right, Matthew, HB 150.
Okay.
I can't hear you.
Can everybody hear me?
Oh, yes. It was
Okay.
only me.
Mr. Subcommittee Chair, if you could enable screen sharing for me, then I can bring a copy of the reprint up. But generally, while that's happening, the bill would establish that adaptive reuse of a property to develop affordable multifamily housing is an eligible use of the proceeds of a loan for specified housing programs administered by the Department of Housing and Community Development.
And you do have co-hosting authority there, Matthew?
Perfect. Okay. So the amendment that I'm referencing is House Bill 150, 150-143-928-1. As the subcommittee will recall from last week, this is the language that was offered by DHCD and the sponsor to clarify that the notice requirements under the bill would not apply when an individual applies for a loan under department programs that are not focused on housing, and then specifies that includes programs within the Division of Neighborhood Revitalization. There is a representative. Sorry. There is a representative of the Department of Housing and Community Development here, but generally the focus here would be those programs where housing is the clear intent, housing developments, the clear intent, other programs where you might have housing development as an element of them, but it's not the highest or greatest use of the available funds. And just to be completely clear, there was another amendment discussed. Delegate Stewart has withdrawn that amendment about seasonal workforce housing. So this is the only amendment being offered on the bill by the sponsor.
Thank you, Matthew. And just to expand upon what Matthew just said.
Hey, Mr. Chairman.
Yes.
Could you talk a little closer to your speaker? I'm having trouble hearing you.
This better?
A lot better.
Okay, thank you. Just to expand upon what Matthew just said, we received an informational letter from DHCD, and the informational letter received from DHCD was addressed in the amendment by the sponsor. I see that Hunter Pickles is on the call, I believe on the call. Mr. Pickles, you want to speak towards what I just said, Matthew just said as well, if you're there?
Yes, sir. As originally introduced, because of where this proposal is in our statute, it would have had the effect of impacting all of our programs, requiring us to offer notice on all of our programs. Basically, some of our programs have very broad uses, although they're not really used for housing. It's conceivable that an application could potentially be an eligible use otherwise, but this specifies that this is only intended for the housing programs, and we believe that this language takes care of the kind of vagaries of it.
Thank you, Mr. Pickles. I move the amendments. Is there a second on the amendments?
Second.
We have a proper motion and a second on the amendments. Is there any discussion on the amendments? Delegate Lehman.
Thank you, Mr. Chairman. Does the way this amendment is worded then, this question is for Mr. Pickles, does that address also the concerns about the CDBG block grant program and inadvertently, is that the bill where there was the concern about CDBG money?
Yes, this was one of the bills that that was a concern, and this would take care of that.
Okay, because I know neighborhood revitalization is a big part of CDBG. So, okay, all right. Thank you. Thank you, Mr. Chairman.
Certainly. Any additional discussion on the amendments? Hearing none. Anyone in opposition of the amendments, raise your hand either physically or digitally. Let me know that there's opposition. Hearing none, the amendments have been adopted. We are now on the bill as amended. Is there a motion, please?
Move favorable.
Is there a second?
Second.
With the HB 150 has been properly motioned and seconded. Is there any discussion on the bill as amended? Hearing none. Anyone in opposition of HB 150, either raise your hand physically or digitally, let me know. Seeing none, HB 150 will receive a favorable recommendation from the Housing and Real Property Subcommittee. Thank you, Matthew. Let us now go to HB 151. And let me have I'm going to have to discuss this before. This is discussion purposes here. HB 151 was voted out of this subcommittee previously. HB 151 was voted out of this subcommittee and was then in the possession of the full committee. The full committee, the chair of the full committee, re-referred HB 151 back to the subcommittee. Therefore, HB 151 is back now in the possession of the subcommittee because it was re-referred back to the subcommittee. The issue that we're going to be discussing today is an amendment. And the amendment that we're going to be discussing, the only amendment that we're going to be discussing is the only amendment that has been questioned previously, which requested that the bill be brought back to the subcommittee. The amendment that we're going to be discussing is referencing notices of mailing and or electronic notices. Matthew, if you could pull that amendment up, I would appreciate it, please.
Certainly. So the amendment you see on the screen right now is amendment number, amendment number HB 151-223-728-1. This actually includes all the amendments that the committee or the subcommittee had previously discussed. But what's most important is the language I starred in the document that I sent to everybody. And this is new language that is being recommended by the sponsor of the bill. It was requested by the sponsor and would allow notice under this new section regarding rent increases to be provided by first-class mail with certificate of mailing, or if elected by the tenant, sent by electronic delivery in at least one of the following forms. Now, this form of notice is meant to match the language that's previous or currently used for failure to pay rent cases. There was a lot of discussion in the subcommittee about potentially this not really acting as an opt-in. So to combat that, the sponsor had asked that additional language be included, such as the landlord may not condition the acceptance of a lease application on the tenant's election to receive notice under the subsection by electronic delivery. And also, I'm just going to scroll up one more page, by making it a prohibited lease term to include a requirement that the tenant accept notice of rent increases under 8209 by electronic delivery. And so that's what the starred language in the document I sent is, what is new and what is being discussed now.
Mr. Chair, I saw your hand up. You're muted.
Yes. Yeah, I was going to ask the question about conditioning the lease, and Matt's satisfied me that the language is appropriate. And I'll just say that I think with that language, the bill does what the sponsor wants, and it also makes sense, and it also protects tenants who do not want to be electronically notified. So I would support the amendment in the bill with the amendment.
Thank you. I'm gonna move the amendment. All the other amendments have previously been adopted. I am going to move right now the amendments that have been starred on the document in front of us.
Second, Mr. Chair.
I see there's been a second on the amendment. Is there any additional discussion on the amendment that we're discussing in front of us now? Seeing no additional discussion, anyone in opposition of the amendment, Matthew, if you could remove your screen, please. Anyone in opposition of the amendment, either raise your hand digitally or physically so I can see that you're in opposition. Seeing no opposition to the amendment, I am now making a motion to move HB 151 as amended. Is there a second? I see a second. Any additional discussion on HB 151 as amended? If anyone is in objection to HB 151 as amended, please raise your hand either physically or digitally so I can record you as in opposition. Seeing no opposition, HB 151 will receive a favorable report from the subcommittee as amended to the full committee. Thank you, Matthew and Mr. Chair. Let us now go to HB 313. Matthew, if you could give us some information. 331.
Mr. Chair, I think Delegate Siliberti has a question.
I can see here. Let me unmute yourself, Delegate Siliberti. You're still muted. There you go. Okay.
We all right?
Yes, go ahead. What's your question, sir?
Just a question.
Yes, sir.
Really. When you ask, Mr. Chairman, for everybody's approval, don't you think it would be best if we raised our hands rather than just assume everybody approves? Just a point, very minor.
Well, what I did was I asked if anyone was in opposition for them to raise their hand. Is there one of the bills previously that you wanted to be recorded in opposition? Well, the vote's over now. But if it is easier, then I will reverse the technique and ask those that are in favor to raise their hand going forward. All right. So now we're on HB 331, and Matthew, if you could go through and give us a brief description on HB 331, that would be appreciated.
Certainly. So HB 331 is a reintroduction. The bill would establish additional requirements for virtual meetings that are held by a cooperative housing corporation, condominium, or homeowners association. The bill would also authorize the person conducting a meeting or the person's designee to take specified actions during the meeting, including removing a participant from the meeting under certain circumstances. Furthermore, the bill would specify that a meeting of a COC held by electronic transmission is considered a closed meeting and may be held only under circumstances specified in statute. The amendment that I have before you, there were two amendments that were sent out, and I just wanted to provide some clarity on that. After reviewing both amendments, I determined that really the language of the two amendments was meant to do the same thing. And I'll talk about it in terms of the and then amendment number that I'm working off of, by the way, is 593329. Both amendments were intended to address this concern. I apologize for the scrolling. where any meeting of the board of directors held by electronic transmission would, by nature of the language that was originally introduced, be deemed to be a closed meeting and may be held only in accordance with the provisions specific to a closed meeting. And similar language would exist for cooperative housing corporations, condominiums, and homeowners associations. Both sets of amendments were intended to treat these meetings as open meetings and subject to the notice requirements for open meetings. And if notice wasn't provided, if you weren't going to meet those open meetings requirements that are in statute for each of these common ownership communities, they could be closed meetings only under the requirements of existing law, or only under the conditions in existing law. So that was the goal of both amendments. That being said, the language in 593329, just, I'll give you my drafter's perspective, I think is a little cleaner. It's a little simpler. It's consistent with the floor standard for these meetings, that they are open meetings and may only be closed under certain circumstances. There are some tweaks, and the one I will suggest is for the condominium language. And that is here on page 8 of the bill. This language here only refers to the requirements in 11-109 that the meetings be open generally. It doesn't address the conditions when a meeting of this nature could be closed. So there'd probably need to be just an additional bit about that. Like if the meeting were to be closed, it would be closed subject to the provisions of section 11-109.1 of the Real Property article, which would make it consistent with the other provisions for the Cooperative Housing Corporation and the Homeowners Association. And if it's the will of the subcommittee, I can make sure that that language is adopted in a final subcommittee recommended amendment.
So let me clarify for those. So the other amendment, Matthew, 413623-1 is not necessary. Is that correct?
Well, it's not that it's not necessary. It's just a different way of addressing this issue, where if the board of directors or if a group, the governing body, were to have a teleconference meeting, instead of a full virtual meeting with Zoom or a full in-person meeting, that would be fine to do as an open meeting. It just must be consistent with the open meeting requirements that are in law for these common ownership communities.
Well, let me ask this question a different way.
Okay.
We should not be adopting both sets of amendments.
Correct. It's
and that's
one or the other. And I think from a drafter's standpoint, 593329 would be the
and that's where I was going. We should not be doing both. We should be doing the amendment that's in front of us, with the exception of on page 8, line number 8, that should be 11-109.1.
No, there should be a separate piece referring to 11-109.1 for closed meetings, and I will work with the sponsor and various the groups that assisted the sponsor, which would be CAI and the Consumer Protection Division, to make sure that language is consistent with how it's done for the cooperative housing corporations and the homeowners association. Make sure that everything is consistent across the board prior to a full committee vote.
All right. So, ladies and gentlemen, just to clarify, what we're discussing and going to be voting on right now is the amendment numbered 593329-1, which is in front of us right now, with the additional provision of referencing 11-109.1. All right, that's what we're discussing right now. That is the amendment we are discussing right now. So with that, what I'd like to do is to ask if any. Let me do this first. I make a motion. I am moving amendment 593329-1 with that other provision added to it. There's a motion and a second. Any discussion on this amendment? And if you could remove your screen there, Matthew, so that I can look at any hands being raised, etc. Is there any discussion on that amendment? Seeing none, all in favor of this amendment, raise your hand. All in favor of this amendment, raise your hand. Delegate Boyce, thank you very much. All right, so that amendment carries. Thank you very much, ladies and gentlemen. I now move favorable on HB 331 as amended. Is there a second?
Second.
And
Is there any discussion on HB 331 as amended? Hearing none, all in favor of HB 331 as amended, signify by raising your hand, please. All righty, it is unanimous. Thank you, ladies and gentlemen. We will now go to HB 639. And Matthew, if you would give us a brief description of HB 639, that would be greatly appreciated. 639.
Sure. So this is the bill that alters statutory provisions that prohibit unreasonable restrictions on land use related to the installation of a solar collector system under specified circumstances. The subcommittee may remember kind of when we left off with this bill last week, I believe it was last week, there was some discussion about an alternative to having an individual producing design documents that would support a finding that a restriction is unreasonable. Having that individual be both certified and licensed, where there is no such licensing in the state, and providing an alternative based on the number of design systems that this person has done. So what I did was I put together the recommended language that was suggested by somebody who's operating in this space and is, I should mention, supported by CAI, or at least CAI had suggested they agreed with this language. That amendment is HB 639-263-721-1. And how that would change the standard now is if you go to page 3 of the bill, and we're looking at lines 13 through 15, the person who produces the documentation would have to be an independent solar panel design specialist who is either certified by the North American Board of Certified Energy Practitioners, and this would strike the licensing requirements since we currently don't license anybody and thus nobody could do the work, or has attested by affidavit to designing at least 50 solar collector systems in the course of trade. So you are one of these solar panel design specialists who either is certified or has done a sufficient an amount of work that would recognize that could be used to recognize you as somebody who's skilled in this business. And I think there was maybe some discussion about whether that number should be 50 or if there should be some alternative used.
Thank you, Matthew. Yeah, I see Delegate Healy. You're going to be next. I quite frankly have looked at that number 50, and it seems a little high to me. And one of the things that I had been thinking about, ladies and gentlemen, is taking that number 50 and making that number 50 relevant or similar to, or at least what I had suggested in the reserve study bill. And I'll have Matthew explain that in a minute, but let me first get to questions. And Delegate Healy has a question.
Thank you, Mr. Chair. And it's just a question I have because just because somebody's done something 50 times doesn't mean they've done it well, or that, that there aren't like lawsuits against them for botching it or having problems. So I wonder if there's any language we could use that could say, that they have done the work well, or in some way to attest that.
Off the top of my head, I don't know how we could qualify the work that's been done. I don't, to answer your question, I don't know,
Okay.
Delegate Healy.
It's just a question. I just not sure, you know, if there isn't, then there isn't. I get that too.
Yeah.
But, it's just a cautionary thought.
Sure, and I totally understand it. Delegate Boyce?
Thank you, Mr. Chair, and I certainly agree with Delegate Healy, even to your point, Mr. Chair, about the number, like you could do something 50 times and could still be terrible at the job. But I guess I don't understand who potentially licenses and regulates in a way like to say you could reference back to that where complaints potentially would be made, or if they're not in compliance, like how do you reference it back to say, you know, X company in good standing with 1, 2, and 3 systems or whatever organizations that may not only license, but would also kind of track their performance based on a customer feedback or based on the standards of which they would have to operate. Just a thought.
It's a very good point, Delegate Healy. Delegate Boyce. That's a very good point. Very good point. Before I get to you, Mr. Wiggins, I want to get additional questions from members of the subcommittee. Matthew, can you remove your screen
Yes.
share there, Matthew, just in case there are any hands and I can't see them? Does anyone else from the subcommittee have any questions at this point? We're just discussing the bill at this point. Mr. Wiggins.
Thank you, Mr. Chair. I was wondering if it may be helpful to just provide a little bit of context in what the bill I think is intending to do. And it's really up above this section of law it's creating an objective standard where there currently is a subjective standard. So a community association can not unreasonably restrict a solar panel installation or solar collector installation if it significantly increases the cost or significantly decreases the efficiency. And so what the bill does is it clarifies the 10% and the 5% thresholds for cost and efficiency to provide an objective standard both for the homeowner and the HOA. And then it provides a mechanism for a homeowner to challenge the restriction as unreasonable. In doing so, they would provide documentation from this independent individual. And so the 50 number, I believe, is just intended to provide a requisite professional level of expertise. I think CAI received that number from the industry representative, Sunrun, who was involved. So it's really just meant as a mechanism that would prevent litigation or something like that. And so that I think is the reason for that number, and in addition to the certification piece that Matt mentioned.
Sure, I understand. And that I agree with you, Mr. Wiggins, that it makes sense to have a number. But as indicated, there's been discussions whether that number of 50 is a good number or whether there should be some other types of requirement so that there may not be a potential to eliminate others in the industry. Delegate Boyce, I'm gonna go to Chairman first, and then
I was about to say, can you go to the chair first?
and then I'll come back to you for your second bite. Delegate Barve, Chair.
Sure, I'm a delegate.
Really? Really?
Yes, still, believe it or not, yeah, they'll elect anybody engaged. So let me just say that I've thought about this little provision for a while, and I've decided personally, and I'm not saying that anybody has to agree with me, that we should just, this provision has the benefit of being similar to something in the Virginia law, so we can explain it at least. But unless we actually go to the extent of regulating these installers at some point in the future, I think I think it makes sense to just keep this language the way it is. Now, at some point in the future, maybe we want to regulate them. I mean, I presume, and Matt, correct me if I'm wrong, would they still have to have a home improvement contractor license, or are they not regulated under that statute?
Well, so I understand that the organization, the business doing this would still have to have some kind of home improvement contractor's license or a master's electrician's license.
Okay, well, you know,
Somebody on.
well, that's good enough for me because, you know, under that statute, if they botch, if you're not regulated properly, if you don't have a license, you can't legally get payment. And so I think in the interim, that's good enough for me at least. So
Is this Matthew, this is the same language that has come from the Virginia statute, is that correct? In terms of just the number, the number 50. I'm just trying to figure out.
yeah,
I don't believe that, well, I don't believe that there's the 50. I don't know that the
Okay,
50
that's
number
fine.
is in Virginia's statute. My understanding is the language of the bill
Yeah,
is
language of the bill,
referencing
right,
language
right,
from
oh,
Virginia.
all right, I stand corrected.
right. I just wanted to make sure, you know, Delegate Boyce.
Thank you, Mr. Chair. I was going to say the same, but slightly opposite to what Mr. Chair said, is that if this is not something that is, while it's a professional business, it's not so widespread. On one hand, okay, you've done 50, but on the other hand, you could be just as proficient and do 10 or 25. I mean, I could agree to just keep it at 50, but the other part of that, it goes back to if there's only 2 and 3 and 4, and there's a spread around of right. So there's only 2, right? And so to the point of competition, when someone else potentially comes into this work, what does that do to them? It slightly undercuts them because it would say that, you know, they've done 45 or maybe they've done 20, and maybe all their reviews say that they've done very good work and to standard, and yet the person who's done 50 may not necessarily be noted as the best company. So I'm fine with leaving it as it is, but considering it's not very, doesn't seem to be very popular as of yet. It just doesn't seem, it seems a little strange to put that 50, that 50 number on it. Just seems so arbitrary. I don't know.
Arbitrary.
All right, I'll shut up. Thank you.
No, I didn't mean for I didn't imply for you to shut up, Delegate Boyce. Did I give
I just
you
started, I feel like I was about to go down a rabbit hole. So I shut myself up. Thank you, Mr.
I see all the questions. Let me suggest something. Keep your hands up, please. Let me suggest something just for discussion purposes. Matthew, in terms of the reserve study bill that was passed last year, and I don't have it in front of me, I'm desperately searching for it. Is it possible for you to pull that up and look at the requirement that was in the reserve study specialist in terms of the numbers that had to be done? And this, ladies and gentlemen, this is just for discussion purposes. I'm not saying let's do this. It's just discussion purposes.
It's like,
Go ahead.
Oh, sorry. So yes, I have on the screen the language about reserve studies under the Condominium Act, and just for the members who weren't here last year, the language is again another one of these instances where we've tried to take the language and apply it to all 3 types of common ownership communities consistently. So yes, each reserve study required under this section shall be prepared by somebody who's prepared at least 30 reserve studies within the prior 3 calendar years. So,
and again, ladies and gentlemen, I'm just pulling this up because, you know, just for discussion purposes. And this language that you see here in reserve studies was language that was presented to me from CAI, who oversees the reserve study specialists across the nation. Now I'm going to go to the questions of the subcommittee members. Mr. Chair.
yeah, you know, I thought the 50 number was in the Virginia law, and if we have 30 in our law, let me just suggest that maybe we should consider amending it that way. And unfortunately, after having dropped that bombshell on you, I have to leave for a meeting. So
That's okay, Mr. Chair. I'll get back at you.
okay, all right.
Delegate Healy.
Thank you. I appreciate, actually, I'm sorry he left because I really want to say I appreciated his knowledge about the contractors law and how these kind of people would have to, in the bill itself, before we put the 50 or whatever number it is onto it, there's still, there's somebody that has some kind of license at stake if it's not
That's
done
correct.
properly.
That's correct.
Either
That's
the
correct.
general contractor or the electrical contractor, somebody is going to, somebody who has something to lose has the responsibility for making sure it's done correctly.
That is correct.
That's the only question that I was concerned about. And so I'm really happy that we have that information. So right now it's just a matter of what is the right number
That's
of hours
right.
to
That's
give
right.
people a comfort level.
Yeah.
I don't know where 50 came from, but I'm agnostic about what the number should be. So
Sure. And the
I'll
only
listen to
reason,
what other people say.
and the only reason that I brought into the discussion the number from the reserve study is because we have something with which to say, if someone says, where'd that number come from? And I don't have to say, I pulled it out of the air or we pulled it out of the air. We have something to refer it to. That's all. That's the only reason I brought it up. Delegate Lehman?
Thank you, Mr. Chairman. Well, now I'm more confused. So I thought I just understood Chair Barve to say something about a Virginia law. What was that?
Let
Mr.
me
Chair,
just
the chair did discuss the Virginia law. Yes, he did. What is not in the Virginia law, Delegate Lehman, is that number 50. That number 50 is an arbitrary number that was suggested to us. That number 50 is not in the Virginia law.
Yeah, I feel like Delegate Healy made an excellent point about that, quantity does not necessarily equal quality. And to borrow the phrase that a lot of young people use today, that number just seems random. It seems really random. So I don't know what the right number is either, or if there's any way to talk about, quality along with quantity to make it more, I don't know, more sort of tangible, but in a different way, in a meaningful way. I don't know what that looks like. I think it would be helpful, but thank you.
And that's the exact reason, Delegate Lehman, that's the exact reason why I had Matthew bring up another bill that we had passed previously last year that had a requirement of number of activities to perform, so that if someone asked while in discussion, if someone asks, where did that number come from? The answer does not have to be, it's a random number. The answer could be, this is something that we use in reference to others performing a task in a separate type of a separate bill, but at least it's a acknowledgement that it has been done this way previously. That's why I suggested this reserve study language. That's why I put it there. So at least we have something to refer it to.
Okay. Ladies and gentlemen, I actually saw that a representative of Sunrun just joined the call and may be able to identify where some other provisions that are tied to the number of systems design might be in law. I've been trying to find the Virginia legislation this whole time. Unfortunately, I don't have the means to quickly search Virginia's code. But Mr. Fiastro is here and he was involved with the creation of the current language that I showed you.
Mr. Fiastro, you'd like to add something to the conversation? Please do. You have the floor.
Mr. Chairman, thank you very much. Representing Sunrun Inc., the number at 50 is a contemplation that Sunrun had in order to answer some sort of equivalency for this design specialist position. The idea is that if you are a solar business and you've done 50 projects, you have somebody on staff that is familiar with pricing, is familiar with design, and is able to come up with a number credibly. The number 50 is not a high threshold for developers. Anybody who's in the solar business should be able to achieve about 50 installations on an annual basis. If you're not doing 50 projects, you're probably not really seriously in the business. So that's the number. The difficulty here is that if we're trying to come up with an alternative number and to demonstrate a significant cost differential, we need to make sure that there's enough people out there that can do that. And the current language, the PV design specialist, limits it to 2. It's not enough. That number might increase, but it might not increase sufficiently. In order to be certified by NABCEP, it's a multi-hour course. It's a heavy, and it's one of their highest credentialings. So we thought that this would be a way to offer an alternative to this more heavily credentialed piece. This installer may have NABCEP professionals on staff, but the design specialist is a really unique certification, and that's the crux of it. So
Let me ask a question, if I could. You mentioned the certification. Is there a number of installations necessary for the certification process?
Delegate, I don't know the answer to that question. I don't know if you need to kind of achieve a new rank in certifications. I imagine that you have to have some sort of field work, but I don't know the answer to that question.
Okay. And again, let me say this again, ladies and gentlemen. I am not pushing one thing or the other. Okay, I want to make that clear. I'm not pushing one thing or the other. I'm simply providing information. The reason why the 30 in 3 years was put into the other bill was because that is part of the certification process to become a reserve study specialist. So there was a method to the madness, so to speak. And again, I want to make it clear. I'm not pushing one way or the other. I'm just providing information at this point. Mr. Wiggins, did you want to put something in here?
Thank you, Mr. Chair. Yeah, I just want to note that I think from our perspective, the 30 number makes sense. We appreciate you bringing that information to our attention. Check my client. We're good with 30.
All right. So ladies and gentlemen, this is what I'm going to do. Right now we have two different suggestions before us. One suggestion is the number of 50 installations. The other suggestion that we have is 30 within, I think it's 30 within 3 years, Matthew. That's based on the reserve study bill.
If it were to match the reserve study bill, it would be having prepared 30 within the prior 3 calendar years.
So, and this is what I'd like to do, unless someone has a better suggestion. What I'd like to do is to put this to a vote of the members. Should we have one or the other? Okay. And whichever one that the members suggest that we should have is the one that will amend into the bill. Does that sound okay to everyone? Sound okay? Okay. All right. So right now, let's do this. Everyone understands what we're talking about here. One side says a flat 50. The other says 30 within 3 calendar years. Those are the two choices that we have before us, unless someone has another one. And I'll wait. Yes, ma'am. Delegate Boyce.
I'm sorry, just to be clear, and I had asked it in the chat.
Oh, I didn't see. I'm sorry, I couldn't see the
50
chat.
within a year or 50 within 3 years?
I don't think the bill. Go ahead, Matthew.
The current language wouldn't specify. It just says you've performed at least 50 designing at least 50 solar collector systems in the course of trade. So that could be 50 in 5 years.
The number 50 has no time frame associated with at all.
So I would say, Mr. Chair, respectfully, it would be hard to then make a decision, because if one is saying 50, I can do 50 in 5 years, that's 10 a year, where the other one says I have to do, I guess it would be the same, 30 and you said 30 in 3 years? So that's 10. So that's 10 a year?
Yes.
Well, you just have to have done 30 within the prior 3 years.
The prior 3 years, but the 50 doesn't give an amount, which means
No,
I
it
could
doesn't
have,
give a time.
could have been doing this for 10 years and just had 50, which I think goes back to, I don't know. Okay, I think I have my mind made up. Thank you.
Okay. All right. So again, ladies and gentlemen, Delegate Baker. Oh, he's clapping.
Yeah, to me, just trying to apply some common sense. I don't think it matters on the years of 30 versus 50. You either have to have 30 completed or 50 completed. That's how I'm looking at it.
Okay. All right.
So for me, I'm going to vote for 30 because someone, as I think Delegate Boyce alluded to earlier, someone that has the experience of at least 30 collector systems could be way better than the person that's done 50. So unless there's a way that you can grade them and you know what their grades are, I don't think it matters one way or the other. I'm going to support the 30.
Okay. Delegate Healy.
Yeah, I think, actually, I think that the 30 with the 3 years, within the last 3 years means that they're current. They're not doing old fashioned stuff that's out of date. So I think that actually enhances the 30 recommendation rather than 50, which it could be open ended. So I think that I will go with the 30 as well.
Thank you, Delegate Healy. And I hadn't thought about that part, particularly with the new standards coming out as frequently as it probably will. That's a good point. And again, ladies and gentlemen, I also make sure you understand my position is I'm not pushing one way or the other. I'm just making suggestions for us as a committee, a subcommittee to vote upon. Okay. So this is what I'm going to do. What I'm going to do is call for a raising of hands in terms of one way or the other. Now, let's be clear on what we're talking about. One methodology is 50 with no time frame. The other methodology is 30 within 3 years. Are we all clear? We're all clear? Okay, so all those in favor of 50 with no time frame in it, raise your hand. Layman. Okay, all those in favor of 30 within 3 years, raise your hand. Okay, so Matthew, that is the time, that is the number and time frame that we're going to put into the legislation, into the amendment. It's going to be doing 30 within the past, within 3 years, not the past 3 years, but
No,
30
I thought it was the past 3 years.
It's
30
the
within
prior
3 years.
The
three
prior
Prior
3
3
years.
years, prior 3 years.
Yeah.
Prior 3 years. Yes.
Okay.
So Matthew, we're going to put in the amendment 30 within the prior 3 years, just as it states in the reserve study bill. Okay, Matthew?
Yep, got it.
I appreciate that, ladies and gentlemen. I appreciate that. Democracy at work. All right, now, that being the case, then, is it
Move the amendment.
Thank you, Madam Chair of Rules. There's a second. There's a second. Any additional discussion on that amendment 30 within the prior 3 years? No discussion. All in favor of that amendment, raise your hand, please. Fantastic. No opposition there. Now, Matthew, in terms of the other amendments on that bill, are we straight on the other amendments? Have they been brought forward to us yet?
Yeah, I mean, there weren't any other amendments. There was just that piece on striking the licensure requirement, which was discussed last week, and then having this as an alternative means, and yeah, I think the amendments are fine.
And just for clarification, last week, did we strike the language for licensure last week on the amendment?
I'm not sure any action was taken on the amendments last week.
Okay, ladies and gentlemen, then we do need now for the second amendment, we now need to strike the licensure requirement because there is no such thing. Okay, we just strike that and that's it.
Move the amendment, Mr. Chair.
Thank you very much.
Second.
All in favor of striking that licensure language, signify by saying aye.
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 Any opposition to striking that language? Fantastic. Move the bill as amended.
Second.
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 The bill has been properly moved and seconded. Is there any discussion? All in favor of HB 639 as amended, raise your hand, please. Any opposition? Delegate Ciliberti, are you in opposition or are you in favor? Yeah. Opposition. I mean, I'm favor. I'm sorry, favor. Got you. Favor. Okay, got you. So it's unanimous. The decision is unanimous amongst the Housing and Real Property Subcommittee members in terms of HB 693 that will receive a favorable recommendation with amendments to the full committee. Now we will go to our final bill, HB 691. Matthew, you're up.
Okay. HB 691. Okay, so as amended, the bill does two main things. Codifies the implied warranty of habitability and establishes general standards for raising a cause of action under the warranty of habitability, and would establish standards for group actions under a lead petitioner for rent escrow cases where multiple tenants have a claim arising from threats to life, health, or safety that exist in a substantially similar or related manner in more than one dwelling unit. So I'm going to just go through the amendment because the amendments are fairly extensive on the bill. I'm referring to HB 691-223-026-1. And I will share my screen now for that. There we go. The amendments generally would, first amendment number 1 is technical. Amendment number 2 would add to the list of examples of conditions or defects that would constitute, if not corrected, a serious and substantial threat to the life, health, or safety of occupants, specifically by adding mold. Amendment number 3 clarifies as appropriate the duties and relief provided under this act for single tenants, the lead petitioner in a group action, and the members of the group of tenants in a group action. Amendment number 4 alters damages and relief provisions under the bill. Amendment number 5 would require separate escrow accounts for each member of a group action and provides for the accounting of and consequences for not contributing to those escrow accounts. Amendment number 6 would clarify that certain local laws preempt the state rent escrow laws under certain conditions. And finally, amendment number 7 would alter the provisions for notifying tenants of a group action. There is one more piece, one more suggested amendment that I had received, and I think the chairman of the committee was going to offer it, but he had to leave. However, I have a copy, so I will just pull it up on the screen now. This isn't in the reprint that I was referring to earlier, but on bill page 5 of that reprint, this would add to the new paragraph 5, a subparagraph 4. And effectively, this language would just state that a failure of a tenant participating in the group action to pay into that tenant's specific individual escrow account that's established may not limit the rights or remedies available to any other tenant participating under the same group action under this section. So I'm happy to take any questions that the subcommittee may have on the amendments or the bill in general. And I believe there are individuals from the various groups that were working with Delegate Stewart on this amendment. I should note this is a sponsor amendment. But yeah, if there's any questions, please let me know.
Yeah, Matthew, go. Let's see that last amendment again, please.
The last amendment, sure.
The last one.
Sure, and I apologize, this was a late development.
This was on page 5.
This would be added, well, it would be added to, you'll see at the top right-hand corner of the document I sent out, it'll say bill page 5, and you'll see a new number, paragraph 5. This would be part of that paragraph 5.
All right, currently, I'm sorry, go ahead, Matthew.
Specifically here, I can show you where the language would come.
Yeah, please do.
My apologies for the scrolling. I know it can be.
That's okay. That's okay.
Yes, here. It would basically be a new subparagraph 4 here. And this is the language that was added specific to these when an individual joins the group action, just clarifying that first off, they have to have their own individual escrow account. That's really the only way practically to do any accounting and determine whether or not people are paying in. And that a tenant who joins a rent escrow action initiated under this section who isn't paying their rent into the court may not raise this specific rent escrow action as a defense for a failure to pay rent action.
Okay. I'm going to open up the floor to questions from the subcommittee members now. And then after that, I'm going to open up the floor to the stakeholders. Any questions from the subcommittee members? Okay, I'm sorry, Delegate Lehman.
I'm sorry, what amendment number is this? I think I'm looking at the wrong one. I'm looking at a
Yes.
printed. Yeah, what number is this, Matt?
The number is HB 691-223-026-1. And I also just wanted to note, because I happen to see them in the call, that I believe Chief Judge Morrissey from the judiciary is here. I should have noted that earlier.
Oh, great,
Okay.
great.
There's a reprint. Okay. I
Yes.
see.
Great.
Okay. I didn't.
Delegate Long.
Thank you, Mr. Chair. Do you mind having, Matt, do you mind just putting it back on the screen really quickly, if you don't mind? I just missed something really quick.
Okay. And is there a specific point in the reprint you would like me to go to, Delegate?
You're on mute.
No, you're in the right particular aspect. Just check some really
Okay.
quickly.
Okay.
I'm good to go. Thank you.
Thank you, sir. Any additional questions from the subcommittee members?
I'm confused. I'm sorry.
Delegate Healy?
I'm sorry. It would help me a lot. I mean, because we've been talking piecemeal about this. If you could kind of put it all in perspective and just kind of go straight through the reprint and the amendments that have been incorporated.
Not a
Just so
problem,
I have a
Delegate Healy.
context for all of this. I'm just not following very well.
That's okay, Delegate. No, it's not a problem. Matthew from the top.
Okay, certainly. So the first amendments here, as always, in the purpose paragraph and the function paragraphs are technical. The various changes you'll see in the first couple pages of the bill, my review of this is there's largely redrafting for style. There is this restatement of an affirmative warranty of habitability on page 2 that is untouched by the amendments.
And hold on a second, Matthew. And ladies and gentlemen of the subcommittee, at any point while Matthew is going through this,
Yes.
while he's scrolling, please ask him to stop so we can address your concern, okay? Continue, Matthew.
Okay. First, and I forget which number amendment this is. This would be amendment number 2 right here, adding to the list of, and I should just clarify that this is a list of specified examples, but there's still a general requirement that a landlord repair or eliminate conditions and defects which constitute, or if not promptly corrected, will constitute a fire hazard or a serious and substantial threat to life, health, safety, or safety of the occupants. So note just here, including these are illustrative examples. It adds another example.
Hang on, Matthew. Delegate Lehman has a hand up.
Yeah, thank you, Mr. Chair. So this is, I agree with Delegate Healy. This is becoming hard to follow. I am looking at a hard copy that my staff provided me, 4 or 5 page hard copy of the amendments. And I was going to question why what I'm looking at says amendment number 1, and it lumps together both the mold hazard language with the tenant serving as the lead petitioner in the same amendment. And now what you're saying, these aren't numbered in the same way. I don't know when this changed or how, or you're bouncing back and forth, maybe, Matt, between the standalone language and then you're trying to show us where it would be in the bill, because this doesn't look like a reprint to me. If it is, I can't tell.
So this is just to clarify, I did send out documents this morning. I had to send out one follow-up document, and that was sent out to the same email I'd been using, same everything. Let me just get when it was sent.
Okay, I see what I think is what you're showing us now on the screen, but you still described the mold language just now as a different amendment. I have that all as amendment number 1. How many amendments are we talking about, first of all?
Okay.
Total that we're going to have.
Total when I was drafting this amendment, I broke it out into 7 amendments. It's all 7 amendments listed all as part of what is amendment 691-223-026-1. So they're not 7 individual amendments. There's just 7 components to 223-026-1. Does that?
Okay, I guess what's confusing is that it's, okay, I think I understand what you're saying. So up at the top is this one number, 223-026/1,
Yes.
but then you break it out, amendment number 1, amendment number 2.
Yes. Correct.
Okay.
Correct. So when I, just for the sake of clarity, when I say amendment number 1, I'm referring to this piece of 223-026.
Hang on 1 second, Matthew. Delegate Lehman, let me ask this question. Would it be easier to go through what you see in front of us now, or would it be easier to go to the interlinear copy of the bill as amended? Which would you prefer?
I think the reprint or interdelineated copy, if that's, but I don't want, if other people
No,
are
that's
more
what I want
confused.
to.
Yeah, is it, Ann? I mean, that would be, if it would help someone else, I'd appreciate that, but.
Okay, no, that's fine. That's fine.
Okay.
All right, so
Okay.
Matthew, continue with there you go.
Interlinear copies, sure.
And see,
Okay.
and see if you can widen the screen, make it a little bit larger.
Does that help at all?
That's great. That's great.
Okay.
All right.
Okay. So amendment number 2 adds to this list of illustrative examples of serious defects to include the existence of mold in a dwelling unit, which presents a serious or substantial threat to the health of the occupants. So that's amendment number 2 in the numbered amendments. Amendment number 3, I'm just, I'll let the subcommittee know that amendment affects a large portion of the bill. But as we're going through, you'll see there was an amendment to strike tenants organizations from coverage of the bill. And this would just refer to a tenant acting individually or a lead petitioner tenant who is heading the group action, as well as any members who join with that lead petitioner. So you'll see that amendment being made in various places throughout the text. The amendments was also strike an action for money damages for breach of the warranty of habitability. The damages for warranty of habitability are defined by case law and would include abatement of the rent, so a reduction in monthly rent paid, or a repayment of a certain piece consistent with the difference between what an individual is currently paying and what they should be paying due to the defects. Subsection I here, this is all the new language having to deal with these joint actions that is kind of a core component of the bill for rent escrow. And a lead petitioner cannot raise a warranty, a lead petitioner in a group of tenants cannot raise a warranty of habitability claim. You can only raise an affirmative rent escrow claim. And that is outlined here in subsection I.
What page is this on?
This is on page, I apologize, just because it's zoomed in, 4 of the reprint. I'll say bill page 4. In the PDF document, it is page 8. Maybe that'll help if I start giving both numbers. Moving on to bill page 5 or PDF page 9. We get to the language I was referencing before, where there was specific language added about individual escrow accounts for all the tenants who are participating. And this is where that language that the chairman would add about the failure of one tenant to pay into their escrow account doesn't limit the ability of other tenants who are paying regularly into their escrow accounts to receive the benefit of the rent escrow statute and any protections offered therein. Going to continue moving down. There's some modifications to the notice provision of these joint actions. So instead of allowing posting of notice on the site after rent escrow is established, the landlord would have to allow the petitioner, the lead petitioner in these joint actions, to notify tenants at the property in a manner determined by the court. So that could just be sending out an email or sending out a flyer, hand delivering a flyer to the current tenants, but it wouldn't allow just it doesn't specifically require general posting, and this was something I believe that was discussed amongst both landlord and tenant advocates. Strikes, well, that might be confusing. Specifies the type of actions that may be presented. So a tenant acting as the sole petitioner can raise issues of rent escrow, warranty of habitability. The tenant acting as a lead petitioner in an action, and this is page 10 of the PDF, may raise issues of rent escrow affirmatively. Just get your indulgence. Going on to bill page 6, PDF page 11. Again, we strike the action for money damages, but if a court orders any relief under this section, so the rent escrow section, warranty of habitability section, tenants or a lead petitioner or group of tenants may be entitled to reasonable attorney's fees, expenses, and costs. Continuing through the bill, moving on to bill page 7, PDF page 12. Continue, as I mentioned in Amendment 3, to make those designations as to where the rights of lead petitioners or groups of tenants or solo tenants apply. This language here is about the distribution of money in the escrow accounts under certain conditions. And then we get to bill page 8, PDF page 13. And this is the language that hopes to hopefully clarify the rent escrow and preemption of local laws. So under the amended bill, except as provided in 8211-1E, which deals with lead escrow related to lead-based paint issues, the rent escrow law shall supersede any local law or ordinance that's of comparable subject matter, except to the extent that the local law or ordinance provides more protection or broader applicability. So if the local law is more protective or more stringent, then it would apply. If the local law is less stringent than what the state standard is, state standard would apply. So that's with the exception of escrow for lead-based paint issues. And so that is running through the whole bill and generally what it does now. And again, if there are any specific questions on any section, happy to take them.
Okay,
I thank you for that. I really appreciate it.
sure. Delegate Naraki.
Thank you, Mr. Chair. Matt, I do have a question about a particular part of the bill. I'm looking at page 5, looking at lines 31 to 32. Does that provision there, does that mean that if a tenant files?
Hang on a second, Delegate Naraki. Matthew, can you pull that up, please, for everyone to?
Sorry, Mr. Chair, apologize.
That's okay, that's okay.
Delegate Naraki, what is lines 31 to 32, you say?
Yes, Matt.
Okay. There we go. And there we go.
All right,
Yes.
now go ahead with your question, please, Delegate Naraki.
Sorry. So does that section basically mean that if a tenant files a warrant of habitability action, then it stops a failure to pay rent case? I'm just trying to get some clarification.
In this instance, I don't think it would stop a failure to pay rent case. It is something that they could raise as an issue, and usually these would be raised, is my understanding, as in response to things that have currently money that has formerly been paid, past payments that are being made. The rent escrow is still the means by which you could defend against a failure to pay rent.
Okay, and then Matt, if I may, one other section of the bill, Mr. Chair, if you'll indulge me, page
Sure.
4, lines 25 through 26.
This language here, an action under this subsection shall be limited to.
Yeah, so I'm just trying to understand what that means. I mean, I think I understand what it means, but I just want some clarification. Does that mean that sometimes I know in my district we have complexes that can be very large, You could be blocks and blocks away from each other. Does that mean if you're in a complex where you are, many, many blocks away, you can still, not in the same building, you can still bring this escrow action? Is that how that would work there?
So I read this as it would apply to multiple buildings in the same complex. The other thing to keep in mind, though, is these have to be substantially similar, these issues that the joint actions are raising. So if you have something in a building and then there's another building that's blocks away in your example, the tenants raising that are still going to have to prove that that the issue they're suffering from is substantially similar. Now, is it impossible? I suppose it's not impossible, but it is fairly unlikely that if you have two buildings with that level of separation, I don't want to speak in generality.
Yeah, no, I'm not.
Look, it could be some structural problem in the buildings, but the way we're all built together at the same time, and they start to fail in the same way.
Sure.
Right. Where I will leave it is it's up to the petitioners to prove that it's substantially similar.
Right. There you go.
That's fair. I wanted to understand the functionality of that.
Mm-hmm.
Right. So it'd be like Matthew said, it's up to the petitioners to make sure that they present that in such a way that they get the action that they're desired. Delegate Naraki?
Yes, sir. Yes, Mr. Chair.
Are you satisfied?
Yes, sir. That answers my questions. Thank you, sir.
All right. Delegate Long?
Sorry, Mr. Chair, raised my hand by accident.
Oh, okay. What I'm going to do now, are there any other questions? Yes, sir. Delegate Baker.
Am I on?
Yes, sir.
Okay, yeah, I was looking at this amendment, but actually, I have a couple of questions here, so explain to me really, really quick how the rent escrow, where does the money come for the rent escrow? Is that where the tenants put their rent money into an escrow versus their own money into an escrow?
Right.
Going to the escrow come from the tenants. No, I'm sorry. Go ahead, Matthew.
Well, I didn't mean to interrupt you, Mr.
No, you got it. Go ahead. Go ahead.
So yeah, this is a placing of the rent money you would otherwise pay to the landlord into these court-created escrow accounts.
So how does it become a court? The
courts would establish the accounts. To that specific issue, again, Chief Judge Morrissey is here. He might be able to offer the best.
So the tenants would have to take it to the courts.
Yes, you're raising escrow either affirmatively as its own cause of action or as a defense in a failure to pay rent action. So
and the good thing, Delegate Baker, the good thing about rent escrow, the thing that I like about rent escrow is the same thing that the chair of the committee said about rent escrow. When there's an escrow established, tenants are actually paying their money.
I understand.
Yes, and that's a good thing there. So no one is skipping their rent payment. It's just going into a different.
I guess the concern that I have, a lot of the repairs that would be needed could have possibly been created or a result of the tenants not living properly in the home. Mm-hmm. The other problem that I have is I was looking at the mold issue, and it talks about mold hazards, dangerous conditions, things like that. Now, I've been in homes already, and I've seen mold that was created by tenants, especially in bathrooms and things like that. Are we talking about those types of molds also? I don't think the landlords should be responsible for cleaning up bathrooms for tenants.
All right, you have two questions there.
Yeah.
The first question you have talks about damages. And in the bill, it explains pretty specifically line item by line item in terms of how those damages are to be identified in order for you to be allowed to put the money in escrow.
Okay.
All right.
I understand. I missed that.
All right.
Okay.
Mr. Chair,
Hang on a second, Delegate Long. We've got two questions ahead of you. All right. All right. Are you good to go, Delegate Baker? Can I go into?
Well, I did have one other question.
Oh, go ahead. Go ahead. I'm not going to try to cut you short.
So earlier you had mentioned about attorney fees. Landlords would be responsible for paying attorney fees and other costs, et cetera, if it got that far. So if it got to where the landlords were exonerated, how would the landlord recoup his attorney fees, et cetera?
I don't know the answer to that question, Delegate Baker. That's a good question. I don't know. Perhaps.
Oh, I lost you.
We have, let me do this.
Wanda.
Let me do this.
Need help.
Judge.
Yes, good afternoon.
All right, thank you. Judge Morrissey, my favorite constituent. How are you today, sir?
Good. How are you, Delegate?
Before I go back to the members of the Housing and Real Property Subcommittee, I'd like to give the judge an opportunity to talk about some of the things that we have been discussing. Judge, you have the floor.
Thank you. And members of the committee, thank you for letting me testify here today. I think some of the confusion is caused by this bill is doing a couple different things. One, it's codifying the warrant of habitability. That in itself is not, that's fine. We have no concerns with that. It actually already exists in the city. But then then the second thing the bill does is that it expands from one person filing a rent escrow to multiple people being able to file a rent escrow. And that comes with a lot of issues for my court, and I'll get to that in just a second. And then the third thing it kind of does is pigeonhole the warrant of habitability claim into the rent escrow, but it allows, typically warrant of habitability claims don't have a rent escrow component to it. Sometimes they do, they'll file separate actions, but sometimes they don't. And you don't really need a rent escrow because it's more of a contractual, you're breaching the contract it comes in as more of a contract action. So it kind of allows individuals to choose whether to pay into the rent escrow or not pay into the rent escrow. And that's problematic from the court's perspective. It may also, and I don't mean to add an element in, if the lead plaintiff or the lead tenant is not an attorney, it may violate 10-206 of the business occupations article, because then they'd be representing others without a license, a law license, and that could be problematic. And then it kind of raises some other issues that we're not sure what to do with. I've only had these amendments for a couple hours, but what happens if the lead tenant drops out? Then who then takes over the case, and what happens if one person in that group wants to appeal? So the district court does not do class actions. We never have. That would be a circuit court function. So it's somewhat confusing to us that this doesn't have the real safeguards that a class action would have, but it would create some of the problems that are resolved by certifying a class action and bringing it in the circuit court. And then finally, I think you all have talked about the attorney's fees. We typically like discretion over to whether to grant attorney's fees or not, so that some cases are very egregious and warrant attorney's fees. Others, there may be there's just a lot of reasons why things can go one way or the other in any type of court proceeding. And so the judiciary always requests to have the discretion to award attorney's fees one way or the other. I don't know if I confused you all or made it any clearer for you.
We got it, Judge. We got it perfectly. We got it. This is a very smart group we got here. Let me ask a couple of questions. I'm sorry, Judge. Are you complete?
If anyone wanted me to explain about the affirmative use of rent escrow or the defensive use, I'd be happy to explain that too.
Sure. We've got a number of hands up right now, Judge. So hang on. Now, one of the things you talked about was the issue of the lead person not being an attorney, which might be problematic. You indicated. How is that different than a pro se person coming into the court? Or is it different? I don't know. I'm not a lawyer.
they could represent themselves. You can always represent yourself as a self-represented litigant, but when you start to represent others, then that becomes the, the practice of law at that point.
Got you. Thank you. And the other question I have, Judge, before I turn it over to the other members, attorney's fees. I think what you said was that attorney's fees would be awarded during the court process. Is that correct?
Right. We would prefer to say that the court may award attorney's fees rather than right now, the way it's written is the court has to award attorney's fees if they find anything was wrong at all with the property, or if they award any relief to the tenant, they have to award attorney's fees. And we would prefer that say may award attorney's fees.
Okay. And I don't have the bill in front of me. So currently what you're saying is that it says shall as opposed to may. You would prefer the may.
Correct.
All right.
Ladies and gentlemen, I pulled the language up that I believe Chief Justice Morrissey is referring to.
Thank you, Judge. I'm now going to go back to the members of the Housing and Real Property Subcommittee. The first hand I see is Delegate Boyce. You have the floor, Delegate Boyce.
Thank you, Mr. Chair, and thank you for essentially asking my question about the defense. Judge Morrissey, I personally want to move this bill because I do think it's a good bill. But between you and I guess counsel, can we figure out the whether or not it is in fact true that one would not be able to defend self and others in court? I'd like to figure out how we can figure that piece out.
Judge?
Well, it's the section is 10206 of the business occupations statute, and that defines when the exceptions to when people need an attorney in court. And it doesn't seem to me to be applicable to this type of case.
So is it in the business section because being a housing provider or a landlord is I guess presumed to be a form of business?
The other way around, attorneys are presumed to be a form of business. So it's regulating the practice of the law in the state of Maryland.
I don't know. I'm hoping we can, Matt, Mr. Mickler, we can get a thorough thought and opinion about that. Because if that is then the case, I think that is the premise of the bill.
So just to clarify, the premise of the bill would be to allow these group escrow actions, I believe. If there was a concern about a lead petition representing both themselves and others pro se and not being a barred attorney in the state of Maryland, that's something that could be addressed.
Right. Well, there are some exceptions in 10206. If you're a law student supervised by a professor, I don't have 10206 right in front of me, but I believe it's if I want to say MVLS has trained individuals, they can come into court under the supervision of an attorney. And there's a couple others, but if it's and it would be great if anyone that would to bring this action would have an attorney, you wouldn't have to worry about that section. But
that goes back
a lot
to
of people are
point.
unrepresented when they come to court.
Right. And I think it goes back to my point. The point of this bill is to bring a collective. But if you're saying the person is not able to do it, here it is. Thanks, Matt. Then that is somewhat the premise of the bill as it relates to escrow.
Yeah, these are the exceptions under B2 are the exceptions I was talking about. I came close. It was MLS.
The person while representing. In a summary of rent escrow proceeding.
It also talks about a person employed by a nonprofit organization. But I agree with you, Delegate Boyce. This is the premise of the bill. And if we can't, we're going to have to figure out a way to make this portion work. I agree with you, Delegate Boyce.
Thank you so much. I'll move on.
All right, Delegate Naraki.
Thank you, Mr. Chair. I do want to echo Delegate Boyce's concerns there, because that definitely would seem to be the premise of the bill. And if that can't work, then there's a problem with the bill here. So that's my one thought. But my second thought, I had a question, and maybe this is a question for Matt, or maybe it's a question for Judge Marcy. I'm not sure who. If this bill creates an action for a warrant of habitability, would a tenant have to pay into an account to bring that action, into like an escrow account to bring that action? I just wanted a clarification on that.
My understanding, Delegate Naraki, is that the warranty of habitability claims are generally being brought in response to overpayments of rent, effectively because there's these existing defects and there's been notice and time to cure the defect. However, I will admit that I'm not a practicing attorney. I don't go to court for these issues. So if Chief Judge Morrissey or even some of the other tenant or landlord advocates out there could answer that question directly based on their practical experience, it might be best.
Judge?
Well, I think the way the statute deals with it is it says that you can choose whether you want to pay in. And if you choose to pay in, it acts more like a traditional rent escrow, where that's a defense to any failure to pay rent action because you're paying your rent into the escrow account. But you can choose not to pay into it. It would not be a defense to a failure to pay rent claim, but it's kind of mixed up in the rent escrow section.
Gotcha.
Okay. Mr. Chair, if I may ask.
Yes, please go on. Please go on, sir.
Judge, one other question. If a tenant were to leave a case right before a judgment, do you believe that this bill would allow them to bring another case on the same issue?
That's a good question, Delegate. I'm not sure I know an answer to that.
Well, I think, I didn't mean to interrupt you, Judge, but I think, and Matthew, Judge, I'm sorry for interrupting, but I think, Matthew, in the bill, it does outline some language relevant to that particular point. Does it not, Matthew?
It does. I'm bringing it up right now.
Thank you. And again, Judge, I'm sorry to interrupt you, Judge, but I just want to get to that point.
Thank you. You're answering the question. Thank you.
Yeah, it would be in subsection I, paragraph 6, what I have on screen here, that prior to the entry of judgment, yes, a tenant who joined in the action may request to leave and pursue any individual remedy.
Okay.
Right.
Thank you, Matt. I missed that. Thank you. I appreciate that.
Right. Thank you. Matthew, if you could, thank you so much. I'm going to go now to Delegate Allen.
Thank you, Mr. Chair. It seems like we still have more questions. I was just going to move the amendments, but we can keep answering questions.
Okay. Thank you, Delegate. Delegate Lehman.
Thank you, Mr. Chair. And I think as Delegate Boyce pointed out, this is the main premise of this bill, this expansion on the language of a lead tenant. It's almost 3 o'clock and we have voting. If we're not in a position to move the bill, I was going to say then we need to hold it. I think it's an important bill and I don't want to see it, sidelined. I know we're coming up against crossover, so
ladies and
I just
gentlemen,
wanted to show.
Sorry, I don't mean to interrupt, but I do want to just note, voting will be at 3:15. There's going to be a delay, so you have some additional time to discuss.
Okay, thank you for the clarification.
Anything else, Delegate Lehman? Okay, Delegate Ciliberti, I saw you raising your finger.
Mr. Chairman?
Yes, ma'am. Yes, ma'am.
If I could say, I don't know how soon you're going to call on advocates, but I understand.
After.
Okay.
Okay. I'm sorry. Go ahead, Delegate Lehman.
Yeah, because I know some of them I think have thoughts on this issue of a lead tenant representing others, and so I'd like to hear from them on that. Thank you.
I'd like to hear from the members of the committee before we go to the advocates. That's I just want to make sure we do a format. You know what I mean? Make sure we get all the questions out, because I don't want to have to go through questions and then go back to them again. Delegate Ciliberti. I'm sorry, Delegate Lehman. You go ahead.
No, I'm finished. Thank you.
Okay. Delegate Ciliberti, you're up. Delegate Ciliberti, go ahead. I can hear you. You're on mute. Go ahead. I'm sorry?
We are okay.
Oh, all right. Now I'm going to go to the advocates, and I'm going to start with Mr. Hill first.
Thank you, Mr. Chair. Matt Hill, Public Justice Center. On this question of the lead petitioner, there's nothing in the statute that I see saying that the lead petitioner has some sort of real obligation to represent the other tenants in some sort of fiduciary sort of or legal representation duty. But even if that is implied in some way by the statute, I don't think it's that much different than in the sense of a class action in which you'd have named plaintiffs and they would then have a class. But again, I don't even think there's that level of duty or obligation on behalf of the lead petitioner. They're just the ones who are kicking off the action and agreeing to make sure that they put their rent into escrow and that their rent will remain in escrow. Because again, rent escrow is not such an accessible form of action for lots of tenants who may not be able to come to court as often and stand up to their landlord by themselves. So we don't think that. Go ahead.
Let me ask you a question on that point, Mr. Hill, before you go to the next point. You sound like you're getting ready to take a breath and go to another point. Yeah, that's a question.
That's what I do.
I'm not an attorney either. So a class action, as I understand it, does not go to district court. Is that correct?
Correct. You cannot have a class action in the district court, and rent escrows have to be in the district court.
Okay, so now and that was going to be my question. How do we separate the two items or the two issues, class action versus escrow? I don't know how to, how do we do that?
Right. So again, I don't see an obligation here for the lead petitioner to represent the interests of the other tenants, unless I'm missing something in the statute. So I don't think it's an analogous. Their real responsibility again is to start the action, pay into escrow, notify the other tenants of the case as the court determines, and move forward as essentially the point person on the case. But there's nothing in the statute that obligates them to represent the interests of the other tenants. But even if there were, again, it's not that different from the kind of class action context.
I got you. Now hold on a second, Mr. Hill, and Delegate Healy, hang on a second too. I do recognize, but we're running up against the clock. But Matthew, if you could, some kind of way, Matthew, AG or whatever, figure out the differences in what is being discussed here, so we can figure out how we can make the bill work in its current language. And before I recognized Delegate Healy and Zephyr, I want Mr. Hill to finish his discussion.
Sure. Just real quick. So to the point of what would happen if the lead petitioner were to drop out, I mean, the court could appoint another tenant as the petitioner. If that needs to be clarified, I think that'd be an easy fix. And to Judge Morrissey's point, if it would get the bill moving, I don't think we'd oppose changing the language to may. The court may award attorney's fees in this context. Sure. I think we still believe in the bill that is draft.
Right. Yeah, I didn't think you would disagree with having too much heartburn with the may. Zephyr, before I go to you, I'm going to go to Delegate Healy first.
Yeah, thank you very much, Mr. Chair. On this very point that you all have been discussing, I wanted to ask if it would be helpful to find some explicit language that says that the lead tenant in the action is not representing the group, but just providing support to the operation. And I wondered if making that explicit, instead of saying what Mr. Hill is saying, is he doesn't see that in the language, if it was stated somehow that that is not the role of the lead tenant. The lead tenant is not an attorney necessarily, and that's not their role as the leader.
I like that. I like that. That would clarify then that they're not putting themselves out there as an esquire. I like it. I like that. All right. Let me, are you finished, Delegate Healy?
That's it. Thank you.
Sure. Zephyr?
Yes, thank you, Delegate Holmes. So I completely agree with Delegate Healy and Matt Hill. I just want to say that section of business and occupations is about the practice of law. And so you could very well just add to this bill to say a lead petitioner may not practice law on behalf of the tenant, the group of tenants that joins their petition.
Right.
I do want to just add a point, which is,
Hang on 1 second, Zephyr. Matthew, you got that note, Matthew?
I do. I
Okay.
mean, if not to muddy the waters, but if this individual were a barred attorney in the state of Maryland and were to take on the case, should they not be able to do that? I mean, should there be some clarity that a lead petitioner who is not a licensed attorney in the state of Maryland may not be able to take on? Like,
yeah,
maybe, you know, okay.
All right. Yeah, Zephyr, I'm sorry. I didn't mean to cut you off, Zephyr. I just want to make sure we start noting things so we can, but go ahead, Zephyr.
So I just want to make a clarifying point because it was suggested that the warranty of habitability is pigeonholed into the escrow statute. And so the context there is that we in practice often do find that before the bench in the district court, a claim for based on the warranty of habitability is sort of translated at the bench as being a rent escrow claim. And so, you know, these are kind of a commingling of facts and issues because they deal with habitability and the question of rent. But the bill is designed to distinguish the two different types of remedies. And I just want to make this one point really clear, that a group of tenants based on the lead petitioner's petition in this bill are only able to seek the remedy of rent escrow. And that means abatement of rent, terminating a lease, an order for court repairs, receivership, and what have you. But the implied warranty type of remedy, which is retrospectively looking at, like Matt Mickler said, like a reimbursement and that type of thing, that's not available to the group. And so that's a change from the bill as introduced. So the amendments are meant to really isolate that an individual petitioner, tenant, I should just say an individual tenant can bring a warranted habitability claim. They don't have to pay rent into escrow in order to proceed with that claim. But the petitioner who is joined by other opt-in tenants, that group is only able to seek sort of like the injunctive relief of the escrow statute, not money damages. Okay, thank you.
Thank you, Mr. Shaw. Let me go to Ms. McDonough.
Kathy Howard.
Yeah. Oh, I'm sorry. Kathy, you're up. I'm sorry. I'm just reading, Kathy. I see your face.
Sorry about that. I had to borrow Caitlin's Caitlin's laptop. We're interchangeable blondes. What can I say? Anyhow, I think one of the things I want to point out here is that I'm not completely comfortable with just saying that the lead plaintiff is not potentially going to find themselves being in Dutch with the statute that Judge Morsi talked about, considering what that lead plaintiff, that lead person has to do. There's an entire list that they have to give you between it has to make allegations of threats of life, health, or safety for himself and possibly the group. Describe each dwelling unit that is the subject of the action, include the name of each tenant, on whose behalf the action is maintained or who has joined the action, and describe the facts on which each claim is based. That is really bumping up against the line. I really do think that is a concern. The other thing that there are a lot of things in this this new reprint that I find concerning, particularly the concept that you could have multiple buildings in a large complex that may or may not have exactly the same problems. I understand, Delegate Healy, you brought a good thing up about maybe there's a structural problem, and I think that could be dealt with in another way.
I didn't mean to cut you off, but in the language it says, somewhere in the language it talks about similar or same issue, I thought, didn't it? Right?
It has to be similar or same issues, but I can't imagine that these things are going to be you're going to have the same shall we say the same water issues or the same in 1,500 units in a complex that is acres and acres together.
I understand I'm not trying to cut you off, but I am.
Okay. I got you.
Only because of the time frame. Now, if you don't mind, Mr. Greenfield, let me go to members of the committee first. And the first person I'm going to call upon is Delegate Long, because he had his hand up first.
Thank you, Mr. Chair. I appreciate it. Listen, I love the discussion. I love the amendments. I just want to suggest we vote on the clean amendment, or vote to move the bill and advance the bill, and we can discuss this further in committee. That's my motion.
No, sir. We're not going to do that at this particular point, Delegate Long. And the amendments, I don't suggest that we do that. All right, at this point, there seems to me to be too many questions that seem to be bumping heads against each other, unless I'm misunderstanding something. But I'll tell you what, Delegate Long, in the process of what we're going through, you are a state delegate, you have one vote just like I do. You made a motion, and I'm going to respect your motion. You made a motion, and your motion was, as I understand it, you made a motion to move the amendments. Is that correct?
Correct.
Okay.
I second.
There's a motion on the floor to move the amendments, and there's a second on the amendments.
Discussion, what amendments are we actually?
There's a motion on the floor for the amendment, and there's a second. Any discussion? Delegate, now, hang on a second. I see hands up. I want to make sure I get this in the proper format. Delegate Lehman, is your hand raised in terms of this discussion, in terms of the amendments? Because we have a motion on the floor. Is your hand raised about the motion on the floor?
Well, I was going to ask what Delegate Boyce is trying to ask, which is to clarify which amendments we're voting on.
Okay, so the answer is yes, you're asking about the votes. That same thing, your question is, Delegate Boyce? I didn't quite hear it.
I'm sorry, yes, I'm just trying to be clear about what amendments are we,
I understand, I understand. I'm just trying to keep the order here. That's all I'm trying to do.
No, I appreciate that. I just want to make sure I am voting on what I want to vote on. I do have a desire to push this bill, but I do not have a desire to push this bill in a way that ends up being detrimental for the main individuals we are trying to protect. And so
I agree with you 100%. And that's the only reason why I was a little bit resistant to Delegate Long's motion. Is only because I want to make sure we're moving in the correct direction. And Delegate Long just said did not meant to push back on you at all. It's just I was not clear either. That's all it was. And Delegate Naraki has his hand up as well.
Yes, sir, Mr. Chair. I do have some of the similar questions that Delegate Boyce and Delegate Lehman had. I love my colleague Delegate Long, but I'm wondering some of these parts of where these amendments are, could they tie into the areas that we have questions about with respect to being an attorney or non-attorney representing, all those kinds of things. I'm just concerned that we don't have those questions answered to properly move some of these amendments.
Thank you, Delegate Naraki. Now, in terms of the process, ladies and gentlemen, we have a motion on the floor. We have a second on the floor. We are now in the period of discussion. Any additional discussion on the motion on the floor? And the motion on the floor is to move the amendments. Any additional discussion? On the motion? Delegate Allen.
Thank you, Mr. Chair. As I understood Delegate Long's motion, the motion was to move the sponsor amendments that we began talking about, and then we can vote on kind of the additional clarifying amendments that Mr. Mickler can kind of gather in the meantime. That's, correct me if I'm wrong, Delegate Long, but that's what that's how I understood it.
I appreciate that, Delegate Allen, to clarify. Delegate Long, is your motion to move the sponsors amendments only?
That's correct.
Okay, and there's been a motion. There's been a motion and a second. I still think that there is some additional discussion necessary on the sponsors amendments. So we have a motion on the floor. We have a second. We're going through discussion. I am going to vote against the motion. And I'm going to encourage my colleagues to also vote against the motion until we get additional clarification on how everything fits together. Matthew, you had a suggestion.
I was just going to say very briefly to clarify the amendments. So it'd be the sponsor's amendment. There was also that amendment from the chairman that I showed that's not in this document here. The members may just want to take that into account and determine whether or not you want to say a full finalized version of the bill with the final amendment. I also was hoping to use any remaining time if the subcommittee was interested in determining other times this week we might be able to meet.
Mr. Chair,
Yes, sir.
I know we have to go, but we could easily adopt the amendments, the new amendments in the full committee voting session. So I just wanted to put that out there for just my particular point of view.
I understand, Delegate Long. I appreciate that. All right, ladies and gentlemen, it is now 3:12. There's a motion on the floor. It's been properly seconded. We've had the discussion. All in favor of moving the amendments, the sponsor's amendments, raise your hand. That is 1, 2, 3. That's 4. All opposed, raise your hand. 1, 2, 3, 4, 5. The motion does not carry. Ladies and gentlemen, we're going to have to pause because we have to be back on the full committee, and we will have an additional discussion on this later. And I don't mean to suggest, Delegate Long, that your motion was improper or that the discussion was improper. It's just that I want to make sure we get all these pieces put together, synchronized. That's the only thing I'm trying to do.
No, understood, Mr. Chair. I appreciate you, sir.
All right. This meeting is adjourned, and we'll pick up this discussion at a later point, ladies and gentlemen. We have 2 minutes to get down to the floor.
Thank you, Mr. Chair.
Thank you. Thank you so much.